confessed to, like, stealing almost every day the last couple of weeks.
Okay.
And she asked, am I going to be fired for this? I need the job. And he was like, well, based off your honesty, and the more honest you are with us, we take that into consideration.
So, because of this, we are going to prosecute you. You understand that, right?
On April 17th, 2025, Boynton Beach Police responded to an employee theft investigation at a Kohls department store in Boynton Beach, Florida, where 18-year-old Sephora employee Samantha Spear had been caught stealing merchandise across multiple closing shifts. She was ultimately charged with scheme to defraud, a felony under Florida law carrying up to 5 years in prison, 5 years of probation, and a $5,000 fine.
No, I don't. Huh? I don't know where the office is. Thanks.
One inside.
Oh, no problem.
How you doing, champ? Funny we see you again. This time we need you. Yeah. All right, so we're going to go to the management office over there. That's where we have her.
Okay. So, what do we have so far?
So I'm going to just take a picture for my record keeping, and then I will give it to you. Her name is Samantha Spear. She's 18 years old. Works for Sephora. She's with us 33 days. We, through a tip and observation, were able to catch her stealing multiple items. And in the interview process, while they were interviewing her, she confessed to, like, stealing almost every day the last couple of weeks.
Okay.
She knows we were caught? Say again? She knows we were caught? She knows we were caught? Oh, well, no. Ricky told me to go.
Okay.
Off quick math that we were doing in our head, she stole a couple $1,000s worth of merchandise.
And you guys
so we told her to be concise because it'll help in, evaluating her future with us. And she asked, am I going to be fired for this? I need the job. And he was like, well, based off your honesty, and the more honest you are with us, we take that into consideration.
That's a crazy question.
Yeah, right?
This footage raises 3 core legal questions: whether Miranda was properly administered and waived, whether the pre-police confession to loss prevention survives a voluntariness challenge under the Fifth Amendment, and whether the pattern of conduct crosses the threshold for scheme to defraud under Florida Statute 817.034.
Keep working here.
You guys have video and receipts for all these?
Yeah, we'll be able to provide that for you. Yeah, from what she told us, she's been doing all the stealing for her family, for her sisters, her father, her mother. So like Rick said, he goes, it looks like your parents, your family put you in a predicament.
Yeah. What can we start with petty theft?
Well, that's what she said. She said she started a couple weeks ago, small stuff, and then she felt comfortable with it, and then it became every day that she was working.
Sounds a lot more like sneaking and fraud.
Oh, she's going to text you.
I saw you walking in the store. I was going to say maybe just hang out for a little bit. What's that?
You guys already got all the information you needed from her?
Yes. I just haven't turned her yet. He kind of gave you a heads up. Just been with us for a month. A little over 1,000.
I made a copy of the receipt. I gave it to you.
That she was 18 years old. Ever how you guys want to do it?
He's going to ask her enough. Are you guys going to prosecute her?
Yeah.
You guys going to trespass her?
Trespass we don't typically do for associates unless she gets stupid, stands up and starts mother effing everybody, but I don't think she's going to. She's an absolute mess.
Is she?
Yeah. Alright, Samantha. So a couple things. Alright. Certainly anytime an associate causes a loss to us, right, there's some ramifications. So the team from Boynton Beach is here to talk to you, alright? So there's a couple things, alright? Here you go. Alright. So because of this, we are going to prosecute you. You understand that, right? Okay. But we still need our stuff back. Okay? Alright. One last thing, alright? This is a promissory note telling us that you're going to make it right with Kohls. Alright? You still have your pen? Alright, your principal amount owed is what you put on this statement, okay? Alright, so you're going to write that there. You're okay, calm down. And then you're going to print your name and put the date. Did you get that water for you? So Samantha, I do have to make sure you just are aware whether or not you sign it or not. It's okay, alright? You are being released from employment, okay?
Yes, sir.
You can't come back to Kohls to work anymore.
Yes,
okay?
sir.
Alright, so these gentlemen are going to have some things that they're going to cover with you. Alright?
Yeah.
Alright.
I'm sorry I cited the same thing.
You're fine. Do you have anything in your locker that we should get for you while these gentlemen are covering a couple things for you?
It's just my bag.
Is it locked?
No, sir.
Okay. What's your locker number?
It's not the right one. It's the one at the very bottom.
What's the very bottom? I don't
think
think
it's
it's a
like
big
the-
locker room.
Is it in this, what locker number is your locker assigned to?
I was originally assigned to like 75,
It's
but
a white-
I
That same row
don't
at the bottom?
I don't know
It's a white
if
bag.
no, it's
The,
yeah, it's a white bag.
Samantha, this is what I would say. Is this gentleman's going to ask you some questions. You be as honest and cooperative with them as you are with me. You
Yes,
understand?
sir.
All right.
It's like in the door. It's like
Oh, yeah.
He's gonna check,
this
he's
one,
gonna check, don't
the
worry.
very bottom.
Alright, Samantha, so I have to read you something before I talk to you, okay?
My Miranda rights.
Yes. Okay. So I'm required to warn you before you make any statement that you have the following constitutional rights. You have the right to remain silent and not answer any questions. Any statement you make must be freely and voluntarily given. You have the right to the presence and representation of a lawyer of your choice before you make any statement and during any questioning. If you cannot afford a lawyer, you are entitled to the presence and representation of a court-appointed lawyer before you make any statement during any questioning. If at any time during the interview you do not wish to answer, you are privileged to remain silent. I can make no threats or promises to induce you to make a statement. This must be of your own free will. Any statement can be and will be used against you in the court of law. Are you willing to talk to me without the presence of an attorney? Okay, so can you tell me what happened?
Oh god.
How about we do this? Let's give her a little breather. Alright, so she could regain her composure, and then we'll continue the interview afterwards.
Okay.
Sounds good, man?
Yes, sir. Sorry.
Just keep listening, Samantha. Everyone's going to treat you with respect. No one's going to yell at you. No one thinks anything. Okay? This was a mistake. But you need to stay calm for us, okay? Can we do that? Can we calm down for a little bit?
You want water?
Get the, go with the customer.
Malfunction. Listen.
The first issue is Miranda. Under Miranda versus Arizona, law enforcement must advise a suspect of their rights before any custodial interrogation. The officer here administered a complete verbatim Miranda warning, right to remain silent, right to counsel, right to appointed counsel, and the advisement that statements can be used against her in court. Spear waived her rights verbally, stating she was willing to speak without an attorney present. The waiver appears voluntary on its face. However, the deeper question is whether Spear was already in custody before the officer arrived, specifically during the loss prevention interview that preceded police involvement. Under Berkemer versus McCarty, the custody standard is objective, whether a reasonable person would feel free to leave. A detained employee in a back office, surrounded by LP personnel, does not meet that standard. But Miranda does not apply to private actors. Under Illinois versus Perkins, the Fifth Amendment's custodial interrogation requirement applies only to law enforcement. Loss prevention personnel are private parties. Absent evidence they were acting as agents of the state, their pre-police questioning is not Miranda regulated. The second and more consequential issue is voluntariness. A confession is inadmissible if obtained through coercion, but under Colorado versus Connolly, coercion requires affirmative state action, not merely private pressure. Loss prevention told Spear that her level of honesty would be taken into consideration regarding her employment future. That is an implied inducement, a suggestion that cooperation would produce a favorable outcome. Because this statement came from private LP personnel and not from law enforcement, the Fifth Amendment bar does not apply directly. However, courts retain discretion to evaluate the totality of circumstances surrounding any statement. An 18-year-old crying, informed she is being fired, asked to sign a financial document, and told that honesty will benefit her presence, a factual record that a defense attorney will challenge. There is also a Garrity argument available. In Garrity v. New Jersey, the Supreme Court held that statements compelled under threat of job loss may be inadmissible in criminal proceedings. If Spear believed her confession was a condition of employment rather than a purely voluntary act, that argument gains traction. The prosecution's strongest counterargument is independence. Loss prevention built a substantial video record. Before any interview occurred, 4 documented theft dates, captured on surveillance. That independent evidence does not depend on the confession's admissibility and significantly limits the practical value of a suppression motion.
We're going to take out through this door right here. So just grab the patrol vehicle and bring it around this way.
I don't think you're crazy.
Alright, so we're going to take out this door. So we can bring the car down. Okay, so I'm going to get a sworn statement from you because you just interview here. So I'm going to have you raise your right hand.
What's the law of your right?
Yes, we interviewed this associate that works for us. She works in the Sephora department. We were actually doing an investigation on her today. Her name is Samantha Spear. Samantha's been with us since March the 14th of 2025. Through her employment with us, Samantha was found to be walking out of the store with merchandise that's not been paid for. Certainly was all found through video review, just following up on daily habits with our associates in our departments. What we found is more than 4 occasions so far came in to interview. Certainly she admitted to many more events, all happening at the end of her shift, walking out of the store without paying merchandise, never making a purchase. So she admitted to $1,000 worth of product.
Call at King Theodore, is he advising that the friend is 97 and present?
And the 1,000, is that the correct amount, or is that just what she admitted?
That's what she admitted to. She's going to bring back all the rest of the product. Could be a difference. It could be a little bit more, but we won't know until it's fully back in.
I'm not sure we can help him.
All right. So that's it for you. I'm going to get
Leave Brandon to let's see in rehab.
Well,
You're 10.
I have an same statement as him, or should I get one from you
Before we
too?
go out there, get
Yeah, you
detention
can,
confirmation.
Alright, I'll just get one from you. So you could raise your right hand.
Okay, so basically Ricky and I were reviewing some audio, video, going over some testing exams that I'm preparing for. And an email came through, and during that email it read that there was possible dishonest associate activity with a particular individual. Upon review, Ricky and I had found on multiple occasions, on different days, her taking merchandise, concealing it either in her Sephora bag or her purse, and exiting the store.
Okay. And you guys wish to prosecute?
We wish to prosecute. It's part of Kohls policy.
Got to ask that too. So do you guys have like a list of the time she stole?
Yes, and that's going to be put into
Including evidence.com?
detail
Okay, cool.
once he gets the information over for you.
Alright.
Yeah, I'll drop a receipt in there for it.
Okay.
It's got the total of what we know until we can get back the rest.
Okay.
Like I said, based off, like I told you when we were walking back here, based off quick math that we did, it's $1,000. So in his interviewing her, he said the more honest you are with us, the better it makes for you during the whole process of it. So basically that was to jog her memory, to make it think harder, like, let me just put everything that I took, because we took.
Yes.
For your mother, you took for your sisters, you took for your father, you took for yourself.
Okay.
And that'll give us an idea.
I need this one with 10 notes. And put me out with the other call that's in my zone by 975Y. The next to that now.
Hey, Barn 321 J10. Yeah, 32348.
But so far, you're going to be able to provide for us today the details on
I haven't reviewed video yet. Yeah, guys, you have video ready?
Yeah,
to look at?
yeah, we have video.
So I could just check it out.
They need to establish whether we have scheme to defraud yet or not.
Okay.
So they've got 4 dates right now. Several $100s worth of stuff. 4 dates. They haven't gotten through all of the video yet. She's admitted to doing this for several more days.
1953.
For possibly 2 weeks. So, find out. Get his opinion. This is part of the stuff you're going to have to do when you're on your own.
Yeah.
If we have the video for the 4th, we can scheme to defraud. The thing is that anything afterwards, at this point, would either be in addition to or a separate thing.
Okay.
So what we need to find out is what we have here today, what we can charge her with. If you guys are good after that and you're just washing your hands clean from this because she's fired.
Will that be the report number?
Then
Yes.
that's a perfect. But we'll get what we can get today. Because that's probably the route that I would go.
Hang out. I'll get
probably
Okay. He's gonna bring his laptop because he's got everything in there.
All right.
We want to document it just on so we can articulate everything we see, and then you guys will submit the videos later. We'll send you a link. You explain this.
He did. Yeah, he got the information.
So then we can figure that up when we're submitting the whole packet to the state.
Correct.
Okay.
It's hers?
Yeah.
Okay.
I bet you thought it was mine, man.
Do you have your ID there so I could? It's up front.
Yeah, I don't carry it. Alright, so here she is last night. Let me pause it. So last night she comes up to clock out. She's carrying the same bag she's currently got in the office. Here you'll see she fidgets around. She's going to grab something off of here and then she backs up.
And around what time is it?
9:04. She actually conceals the product at 9:06. So here she's looking at something. It's what she winds up taking, but she doesn't take it quite yet. Coach
So it was that speaker that we smelled.
Yeah. So she'll walk over here, walk back.
Now, is we're putting items in there?
No, not yet. She's already got a Sephora bag in her purse that she had already taken from inside the shop. But this is one of the first things that we saw her do. She'll go back out there on the aisle and she'll conceal a speaker that's out there. Alright, so here. I'll back up just a little bit so you can see what she does. So she grabs, there's a Sephora bag back here. So you'll see. She grabs that bag. So you'll see there's already, I don't know if you saw it, there's already a couple things in there. She comes over here. Store's closed, by the way. It's 9:13 at night. We close at 9.
Okay.
She grabs here and here.
The third issue is the charge itself. Florida distinguishes between simple theft and scheme to defraud for a critical prosecutorial reason. Aggregation. Under Florida Statute 812.014, a single theft of under $300 is a misdemeanor. Charged individually, several of Spears' incidents might not reach felony territory. But under Florida Statute 817.034, the scheme to defraud statute, all thefts committed as part of a single ongoing scheme are aggregated. The scheme element requires a systematic, continuous course of conduct. Theft occurring nearly every working day over multiple weeks using the same concealment method at the same location satisfies that element conclusively. The aggregate admitted value of approximately $1,000 crosses the threshold for third-degree felony treatment. If additional video review confirms a higher total, the degree of the felony could be enhanced accordingly. Regarding the promissory note, this document carries independent legal weight beyond the criminal proceeding. A signed acknowledgement of a specific dollar amount owed constitutes a civil admission of liability. Kohls could pursue a separate civil action to recover damages regardless of the outcome in criminal court. Spears' decision to sign this document without counsel is a significant strategic error, though one that is entirely understandable given her age, emotional state, and the circumstances in which the document was presented.
You good?
Yeah, I just thought about it.
What?
How was a female 1037 beat her on the back.
Yeah, I'm gonna figure it out. Don't worry.
11 and 7.
Take 20.
I'll be right back, sir.
Anything else on?
Take 20.
Sorry. Transporter.
Just turn your wrist down.
Take 1. Yes, again.
Second block. 2-4 Delta. Uniform Juliet Papa. Uniform EJ.
Take 100 North Federal. Outside one.
Check some kind of outfit.
Come outside chasing.
Something.
Chasing, thank you.
Work has 2 shifts left, and I'm making her work.
Just 2?
Yeah, we're northeast 6th Avenue in Federal. Have a 640.
Hey, I think they're hiring in Sephora. Oh, there you go. Good day, I was looking at.
Oh, they're trying to get the receipts.
She'll go and just start knocking stuff off, putting it in the Now, we have controls in place that's supposed to prevent that shit from happening. It's like the 4th DA I've taken out of here with a store team time to package shit, something it should be.
How you guys catch wind of this?
Actually, the store associate gave us tips that she was acting weird, so we started reviewing video of all of her closing shifts, and just boom.
read the email, I'm like, hey, I think we might have something.
Good for that
Give it a
person.
quick check.
Started with this.
Over here.
We saw her conceal this last night. Now we're at this. Crazy. So
You got everything we need?
you can have that, my friend. So I'll put. Is it okay if I put you
And
in
you haven't
our
even gone
internal
back.
report as the officer?
They might
Perfect.
be
And I have the report number. I'll send every video that I have. Do you want me to only send the video for this right now?
Yes.
Okay.
Yeah.
Then what do you want me to do secondarily?
Well, the thing
If we
is
find
we're charging
more.
over scheme to defraud, so we've already seen that.
Yep.
Anything that we're doing, it's already like, it would just strengthen the case if you wanted to. It would be a supplement to the report, but it wouldn't be additional charges.
Yeah, fair enough. I don't
So what we're doing is
Whatever
what we
you
have
want.
right now, but
Okay.
because it's the systematic theft over and over again, it wouldn't be additional charges. That's what this all kind of encompasses.
Sure. Yeah. I want to give you whatever you want. So you just.
Because like, let's say that you come back later and it's a much higher amount or whatever it is. Maybe there's an enhancement.
Sure.
I think there's an enhancement for the type of the amount that's being taken, right?
Yep, I don't think she's ever going to reach that. I think it's like $100 or something.
Oh,
I was gonna say, is it over like a crazy?
So
number
it
or
just
is that-
strengthens the case, but we already have quite a bit, and she's confessed.
Sure. No, I mean,
Right.
just, we get knocked over like food shit. We still had like 400 cases last year, just straight shoplift. So
And that's what you caught. So,
yeah,
Keep
exactly.
calling us.
Yeah, we will. Appreciate it, guys.
No
Thanks for all
problem.
your help. Sorry for all the time. No
No problem.
Have a good one. Take care.
Responding officer grade B+. Miranda was properly administered, evidence coordination was thorough, the decision to allow Spear time to compose herself before continuing reflects sound judgment both professionally and tactically, as a composed statement is far more resistant to a voluntariness challenge than one obtained under duress. The grade stops short of an A because the officer did not document the LP inducement issue in his report, a step that would have strengthened the case's resistance to any future suppression motion. Samantha Spear grade C+. Spear waived Miranda and spoke without an attorney present. She signed a promissory note without legal advice. Both decisions compounded her legal exposure at a moment when silence and counsel were her most effective tools. Credit is given for full cooperation, non-resistance, and voluntary return of all merchandise, factors that carry weight in prosecutorial discretion and judicial sentencing, even if they do not affect culpability. Loss prevention team grade B-. The investigation itself was methodical and legally sound, tip-driven, video-documented, and properly coordinated with law enforcement before any confrontation occurred. The deduction stems from the implied inducement language, suggesting that honesty would factor into employment outcomes during what was simultaneously a criminal investigation, creates a voluntariness issue that benefits no one, not the investigation, and not the integrity of the evidence ultimately submitted to prosecutors. Kohls and Sephora, Grade B. The institutional response was evidence first and legally coordinated. Building a multi-date surveillance file before initiating any confrontation is best practice. However, asking an emotionally distressed 18-year-old who has just been terminated and has had no access to counsel to sign a financial commitment document creates procedural exposure that sound policy should prevent. 3 lessons from this case. First, loss prevention personnel should be trained to avoid any language linking the extent of a suspect's cooperation to employment outcomes. That single statement created a suppression argument where none needed to exist, given the strength of the independent video evidence. Second, law enforcement officers responding to employer-initiated investigations should document the conditions of any pre-police interview in their report. Whether or not suppression ultimately succeeds, acknowledging the issue proactively is stronger than leaving it unaddressed for the defense to raise. Third, anyone confronted in a retail theft investigation, regardless of guilt or circumstances, should decline to sign documents and decline to make statements until they have had the opportunity to speak with an attorney. Cooperation has real value, but it is most valuable when offered on terms negotiated by counsel, not surrendered unilaterally under emotional pressure. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.